Hangout with Connect First and PACE, what really happened with the TCPA. My name is Chris Herrick, and I'm the VP of Chapters and Conventions for PACE, the Professional Association for Customer Engagement, and I'll be the moderator of today's Google Hangout. First, let me introduce our esteemed panel for today's Google Hangout. First, we have Michelle Schuster, and Michelle is the partner with the law firm of McMurray, Peterson & Schuster, and is the former Ohio AG Consumer Protection Chief. She has established a solid record of assisting clients in teleservices audits, consumer protection matters before state attorneys general, matters before before the Federal Trade Commission and Federal Communications Commission, advertising compliance, and privacy issues. Michelle is also the General Counsel for PACE and is a certified information privacy professional. Say hello, Michelle.
Hello, everyone. Welcome to the first Google Hangout. I'm very excited to be here. This is the first Hangout, and I think this technology is very cool. I'm excited about using it in the future. Thanks for joining me.
Great. The next person that we'll go ahead and introduce is Courtney Keough, and she is the President and CEO of MarketLink Incorporated, an allied global company. And Courtney is an 18-year veteran in the call center industry, specializing in inbound and outbound sales application, predominantly for the communication industry. She holds an MBA from Drake University and a BA from the University of Northern Iowa. So Courtney, say hello to everybody.
Hi, everyone.
Okay, great. And finally, we have Jeffina, and Jeff is the primary architect of the Connect First platform. He has taken the product through 4 generations of insatiable desire to develop the most full-featured, high-scalable, fault-tolerant, and secure cloud-based contact center solution on the market. Previously, he was a senior-level software engineer at Versati Interactive, where he managed a team of developers responsible for deploying and managing a speech-enabled voice XML platform for Pfizer Pharmaceuticals Incorporated. Prior to Versati Interactive, Jeff was involved in building secure enterprises-grade e-commerce software for Mountain Media, a provider of e-commerce and content management systems. Jeff spends his downtime with his wife and 2 children, thrashing a road bike up a mountain, skiing, and driving race cars. So Jeff, say hello to everyone.
How's it going, everyone? Thanks for joining us today.
I will let you know as we're going through the Google Hangout, there is a question section on the right-hand side. So if you have any questions as we're going through, you can feel free to type those in. And as we get closer to the end of our Google Hangout, we will take your questions that way. So the first thing that I'm going to do, everybody, for this panel as we're going through is what are the top 3 things that you have seen happen since October 16th? This would be with your own organization, a client's organization, or otherwise. Courtney, you just popped up on my screen, so let's start with you if you wouldn't mind. Courtney might be having a hard time hearing us, so Michelle, let's go over to you.
Sure, happy to get things started. So I think it's probably a good idea for us to start by talking about what are the changes that have affected our industry. And really what we're talking about are calls using ATDSs, or automated telephone dialing systems. And I'm sure most of you are familiar with this, so I'm going to go over it very quickly, but I think it's important to point out what the changes are. First, if we're talking about calls that are not telemarketing calls, then the consent standard that was in place prior to October 16th still applies. And that means you need prior express consent to call a consumer on their cell phone or call a person on their cell phone for a non-telemarketing call. Prior express consent is defined by the FCC as a consumer providing their cellular telephone number to the business that's calling them. So this was a very important victory for the industry to at least have that be maintained as the current standard. For telemarketing calls, the level of consent required was increased to express written consent. So you must have express written consent if you're going to make a telemarketing call, either to a consumer's cellular telephone or if you're using a pre-recorded message to their landline, their residential landline. There are various requirements for express written consent. We're not going to go into that now, but make sure if you're relying on express written consent that you have that. So that's the changes that we're talking about. A lot of the discussion since and immediately prior to these amendments was around what constitutes an ATDS. And I don't think we have a clear answer to that. So I wish I could tell you the one thing that has changed since October 16th is we know what an ATDS is. I think that there is still a lot of room for interpretation as to what constitutes an ATDS. Currently, PACE has a petition in front of the Federal Communications Commission seeking clarification on what constitutes an ATDS. Basically, the definition of ATDS is any system that can make a call in a random or sequential manner, or it can be paired with equipment to make that call. Subsequent interpretations have added an element of human intervention that's not in the definition, but has been used just by courts to interpret what's an ATDS. I have a number of cases that I could talk about that have different slants on what is an ATDS. There's probably been about 10 decisions since October 16th. Unfortunately, they're interpreting the previous law, but the definition of ATDS has not changed. So if you're interested in getting those, that's something I'm happy to share. The interesting thing that's happened in the courts with these types of TCPA decisions is that one court in particular has decided that it won't make a decision, that until the FCC clarifies by way of responding through an FCC decision or order that what specifically an ATDS is, so until it responds to all of these petitions, including PACE's petition, that the court doesn't have the ability to make a decision. So that's been a very interesting development since October 16th. Unfortunately, not all courts are taking that tact, and the FCC has not issued any type of decision to date. What I will tell you, and I don't think this is news to anybody, I'm sure you are hearing about it from people in the industry on a weekly, if not daily basis, because I am, that consumer class actions have doubled through the course of June of 2013 through the end of the year, and I would say they've probably tripled now up to this point, with new consumer class actions around the TCPA being filed every day. I can tell you that some trends we see on those consumer class actions that are being filed are that they're primarily being filed in California, Florida, or the Northern District of Illinois. Although having said that today, I received a call from a company that's been sued in Billings, Montana for a TCPA case. So I can tell you they're primarily in those jurisdictions, but not exclusively, and the cottage industry of consumer class action attorneys has spread far. I will also tell you that in the consumer class actions that are being filed, the states that also, in addition to TCPA claims, are bringing in state claims with those primarily are California, Florida, and Washington. And Washington because of their very strict calls to cellular phones law. So, you know, from the perspective of legally, we don't have a decision from the FCC yet that gives us any type of clarity around what constitutes an ATDS. We are seeing courts struggle with this, so there is no uniformity in decisions in some courts, a court deferring or deciding not to make a decision until the FCC does. And we have a number of petitions that are pending in front of the FCC that I think have to be acted on by the FCC sometime in the next 6 months, although statutorily there is no time frame for them responding.
Thank you very much, Michelle. We appreciate that. Jeff, what about you from the technology side?
So we've seen definitely a significant decrease in certain customer bases and the number of outbound calls they're making on a daily or weekly basis. Some of that is that customers have just decided to completely eliminate cell phones from their calling lists, and thus they have a lot fewer people to reach. The other thing we've seen is that a lot of customers have switched to either manually dialing cell phones or using solutions like what Connect First offers, which is our TCPA compliant dialer. It is basically a glorified CRM with a click to call, and as Michelle was saying, there's still a lot of clarification on what is going to be declared in ATDS, but we're pretty confident that the solutions our customers are using are all relatively conservative and will probably allow them to avoid any ATDS-based lawsuits. We've also seen a big uptick in customers using services like DNC.com's scrubbing to, in an automated fashion, remove cell phones and do not call records, as well as using some of their whitelist management tools. So I've seen a lot more gravitation toward relying on technology to stay in compliance, whereas before October 16th, it often kind of felt like the Wild West. People were, even though TCPA was in existence, it didn't seem like anybody really paid attention or really cared.
Okay. Very good. Courtney, are you back with us?
Yes, I am.
Okay, great. So I don't know if you heard the first question or not, but we're talking about the top 3 things that you have seen happen since October 16th within your organization, with your client's organization, or otherwise. Do you care? Could you expound on that from your perspective a little bit for us?
Sure. I mean, obviously putting the solution in place and making sure that you're compliant was first and foremost. But since the 16th, for us, it's really about having to manage really now 2 different systems for dialing, one calling landlines and one calling wireless numbers, and with that comes a lot of complications, everything from licensing to separate lists to management to agents to separate logins. So once you're getting everything in place, managing it on a day-to-day basis really doubles the complication because you're doubling the technology that's needed to call the same amount of people. Also for me, it's really having to look at new metrics and new KPIs that we as an organization really didn't look at before. So for example, dials per hour. It was something that the equipment did for us before, but now because there's manual intervention, we have to have agents pressing keys and doing different things to make sure that we're dialing as efficiently as we possibly can. So looking at preview time, how long does it take before a record pops up till they actually go into dial it. So looking at statistics differently has been really important for us on an agent level. And then also, there's been some positive performance results and some challenging performance results that come along with this new regulation and having to dial within it. So, some of the positive things we see is that because you're not using the same equipment to dial, we actually are finding that people that maybe the calls didn't go through before are now coming through, and that maybe people that because there is absolutely no delays, that some people are picking up the phone that maybe are staying on the line and listening to the agent that wouldn't have before. So although we've seen contacts per hour drop 20 to 30% with this dialing, we've actually for the most part seen an increase in conversion rates and are having conversations with people maybe that we otherwise may not have.
All right, fantastic. Great feedback from all of you. The next question I'll go into is what steps has your organization taken to ensure compliance, or what steps have you seen your clients take? And Michelle, I think this is probably a good one to start off with you as well from the legal standpoint, and then going into from the technology as well as from the contact center side in and of itself. So Michelle, we'll start with you again if you don't mind.
So Jeff and Courtney did a great job of really kind of teeing this up already. I kind of flew by the definition of what an ATDS is and flew by some important things that Courtney and Jeff highlighted is really what the issue is out there in the trenches. So for ATDSs, what companies have been looking at is, are they an ATDS? And you're an ATDS if you have the capacity to store telephone numbers and then to randomly and sequentially dial those telephone numbers. So what companies have been focusing on is coming up with solutions like Connect First that have the ability to dial in a way that doesn't have the capacity to randomly or sequentially dial. And unfortunately, because of because of a decision by the FCC, they have alluded to the fact that all predictive dialers are ATDSs. So what we're really looking at is companies having to go back 10, 15, maybe 20 years to configure their dialers in such a way that they don't have the capacity to randomly, sequentially, or predictively dial. So that's really where the focus has been in working with clients. They have taken the position that if they are going to continue to call cell phones, they're going to have a good process in place to scrub for cell phone numbers, and then they're going to have a separate process for calling those cell phones, a separate dialer, a standalone dialer, so that it can't arguably be lumped in with a predictive dialer and therefore have the capacity. So we've written a lot of decisions. I know a lot of companies out there have gotten legal opinions that really focus on two separate things. The first is that they have experts come and look at their systems. So from a technology standpoint, in looking at that system, does it have the capacity to randomly or sequentially dial? Does it have the capacity to be a predictive dialer? In other words, is it an ATDS? And that's from that very technical side, having somebody look at the technology. And then they pair that with a legal opinion that gives the current state of the law, absent any clarifications by the FCC, and most of these take a very conservative approach, that based on the ability, the lack of capacity of a system to function as an ATDS, and based on the current case law, that it is not an ATDS. And the reason people are doing that is because they want to have some type of defendable position should they be contacted by consumer class action counsel inquiring about what steps they took to make sure that they weren't violating the TCPA. So that's what we're seeing out there.
Thank you, Michelle. That's great. Courtney, do you want to go into, from your standpoint of it, from a contact center provider?
I mean, sure. I mean, steps to ensure, number one, as Michelle said, I mean, you have to have completely separate systems, and that's separate hardware, separate software, separate databases to house everything. You know, as I said earlier, that means separate logins and separate passwords for every agent. And then it's really about putting policies and procedures even further for agents, but more for efficiency standpoint as well. So just as Michelle said, I mean, we had to get position statements and certifications from our dialing company to ensure that what we're using is not an ATDS. Also getting the legal opinion on that. Again, making sure that you know, that we as a call center are protected and that we're protecting all of the clients that we represent.
And Jeff, do you want to continue on then from the technology standpoint?
Yeah, so we took very similar steps. We spent a tremendous amount of time looking at our architecture, looking at everything that in the past has defined an ATDS, and coming up with a solution that was very clearly outside the scope of anything that had ever been determined to be an ATDS in the past. We then took it a step further and had a number of legal experts review our architecture and give us their professional and legal opinion on what we were doing. So we've had a lot of third parties look at our product and kind of give us their blessing to tell us that, you know, we are offering our customers what we call a safe product. So, and you know, as we were saying before, it does require separate agent logins, separate set of reports. There can't be any crossing the boundaries between what our predictive dialer can do and what our TCPA solution can do. So it does add a lot of management overhead for the contact centers, but that's kind of the position that everyone's been put in, and we're just trying to find solutions to help our customers minimize the inefficiency that they're kind of being forced into. On the client side, like I said before, we've seen a lot more customers sign up for our DNC.com integration to scrub out cell phones and do not call leads. We've got a pretty in-depth whitelist management suite that allows customers to manage their express written consent. So we're just seeing customers that are that haven't been scared off and just eliminated cell phones from their lists, really moving toward relying on the technology to stay in compliance.
Fantastic. So I have some specific questions for each of you, given your areas of expertise. So Courtney, if you don't mind, I'm going to start with you. Okay. Because how would you say that your business has really been affected leading up to the changes and then since the changes? And would you say, has there been positive, negative, or no change, or maybe a combination of all of those?
Really, Chris, I'd say there's a combination. Certainly the negative impact is that you have lower contacts per hour. So calling, if you will, is not as efficient as it once was using a predictive system. On the flip side, as I mentioned earlier, because of ringtone rules and answer machine detection and so forth, and not having any of that on the wireless system, again, we are seeing stronger conversion rates in most of our sales programs and further list penetration due to the fact that we're able to contact more people for a definitive yes or no. Again, maybe before that number, if it had a wireless number with a ringtone, maybe the system would have coded that as an answering machine before, and all it was really simply saying is, please hold while your party is reached. And now the agent is hearing that, they're able to hold on and actually have some conversations that they weren't able to have before. But we are experiencing 6 to 7 contacts per hour, which again is about 20-30% less than you would see on a predictive system. For some of the agents, they actually, it varies. Some prefer the calling on the predictive system. Some prefer the calling on our wireless solution. They are having certainly less conversations per hour on the wireless solution, but they're busier, if you will. And so busier, I mean they're having to press buttons and code calls and do different things. So sometimes, although they're not having as many conversations, they actually feel like they may be busier and therefore perhaps more attentive, and one of the reasons why sales results are stronger.
Have you been able to, just kind of a follow-up call with that, Courtney, or question for that, Courtney, have you been able to match the agents with the type of dialing structure that they're happier with?
Yes, we've certainly tried to do that, and we, in an ideal situation, we have certain centers that only focus on one of the platforms versus the other. Not always possible, but yes, there's definitely a preference with agent. And so because you have to manage things differently and looking at different statistics, as I mentioned earlier, we try to keep a center and those supervisors and those agents as focused on one type of calling if we can, because again, as mentioned earlier, you definitely do have to manage the center differently depending on which way you're dialing.
So they become experts in that arena, so to speak.
Exactly.
Fantastic. Michelle, this question is for you. What do you think has been the biggest difference between the media hype in the TCPA legislation and the realities of the change?
I guess it depends upon which media hype you're speaking about. There's always two sides to this story, and you saw it even with Pace's petition that was filed. We filed the petition, and we had widespread support among the business community for the request that we were making within that petition to have the definition of an ATDS clarified. For those of you that don't know, the two requests there were, and I think it's clarity that all of us on this call or on this hangout would be seeking, and that's that if a call is placed with human intervention, it's not an ATDS. And when we're talking about the capacity of a phone system to dial, we're talking about the present capacity, not the theoretical capacity, at any point in time, but the present capacity as dialed. So on the one side, you've got widespread business support for that type of thing, and on the other side, we had one comment in particular. Most of the comments that were opposed to it were the serial filers who are against any type of clarification at all of the TCPA. They think it's perfect the way it is right now. But the one was from the Consumer Law Institute, and they really largely misunderstood what we were requesting, and we filed a reply comment to that. But so on the company side, I think you saw media, and I'm not going to call it hype because I think it's a reality, that they have been put at significant risk if they want to call cellular telephone numbers without express written consent or express consent, depending upon the calls they're making, of being sued in a consumer class action. We're seeing it every day. So I think the hype, if you want to call it that, has become a reality, and we're seeing in the statistics for consumer class actions. You know, on the consumer side, I guess, and Courtney could definitely and did definitely speak to this better. You know, consumers are getting less telephone calls now on their cell phones just because of the inability to dial. There's a 30% reduction, is what I'm hearing from Courtney's statistics. So, consumers on the other side are receiving less phone calls. Is that something they truly wanted? I would say that the consumer advocacy groups would say that consumers don't ever want to be contacted on their cell phone. Having been a consumer advocate, I would say that it scares me to think that there is a group that thinks that they can speak for all consumers like that. And I can tell you, as a consumer, there are people that I want to hear from on my cell phone, those that I'm currently doing business with, so that I can maintain those business relationships, because I don't have a residential landline that I answer very often. So the hype, I think, it's been a reality. I think we're seeing what was predicted: more consumer class actions and less consumer calls.
Fantastic analysis. Jeff, you answered this quite a bit, but anything that you want to go in deeper from the standpoint of how can the technology really help businesses with being compliant with the new legislation that's out there?
So I think the leveraging the technology will just take a lot of the guesswork out of any scenario where you are brought into a legal dispute, and using the reports and the documentation from your vendor, all those things will give you a much stronger defensible position if for any reason you do attract the attention of somebody who decides that you're a good target for a lawsuit. Aside for just using the general features and functionality and leveraging every vendor's technology to its highest capacity for creating as many efficiencies as possible.
Yeah.
Witnesses, because that's what happens. Should this, as Jeff was saying, should this all go bad and you're required to defend yourself in court, the most important thing to have is going to be an expert that can say under oath that your system is not an ATDS, that you did not use an ATDS to place the calls. So you have to make sure that you have that documentation. You've got to make sure you have somebody that's ready to go into court and testify on your behalf. And then you just have to make sure that, with that being said, you understand all of the other nuances of the law. Chris, did we lose you?
I'm back now. Can you hear me?
Yes.
Yes.
Okay, great. So, Courtney, from your advice then for the listeners, what processes or training or productivity advice do you think you would have then?
Yeah, the biggest thing is, as I kind of said earlier, is because you're on a different platform completely, you're having to manage it differently, and making sure that you're looking at things that are related to efficiency that perhaps really the dialer did it for you. Watch those things that helped you along the way. So you have to train differently. You have to quality assurance things differently, and you certainly have to manage from a frontline standpoint very differently than they once had to if working just on a predictive system. But what I do want to add that the clients that we're representing, we are seeing very strong results from calling wireless lists using this solution. And although that the contacts per hour have decreased, people are still buying, and the conversion rates are very high. So Even if you may ask somebody, do you want to be phoned on your wireless or your cell phone for solicitation purposes, and their answer may be no, these people, when phoned, are buying, which tells me that, when you're selling and talking about products and services, it's still a very viable solution to be calling these lists. So again, because we have been able to come up with technology that abides by all the TCPA and so forth, it's still a very viable medium for contacting people on their cell phones.
And I think it probably goes without saying, don't ever just assume that you're following the correct procedures. Always continue to follow up and make sure that you're following those on a continual basis. Jeff, are you back with us?
I am here.
Okay, great. So the last little bit of advice before we go into the questions that we've had come through. So what advice would you give on the technology side to the listeners that we have today, from the folks that we have that might be contact centers or teams that are working with vendors to ensure compliance on that technology front?
I would just advise everybody to really vet the solution that they've chosen. Make sure that your vendor or your technology provider has done their due diligence to really understand the legislation. There's a multitude of folks out there who say they're providing a non-ATDS solution, but really it's just a predictive dialer set to a 1-to-1 ratio. There's definitely a big gap between the folks out there who are advertising that they have something you can dial with and the folks that actually did produce a truly substantially different product to help contact centers stay in compliance. So, we're, as a vendor of these technologies, we're always willing to give our customers any documentation from an architectural standpoint. We're happy to pass along any of the legal opinions that we've received. So pretty much if you're out shopping for something to call cell phones with, make sure you're shopping for the right solution, not just a solution.
That makes absolute sense. Probably the best advice. Okay, so panel, we've had a couple questions come in, so I'm going to read these and I'll let whichever one of you thinks that you would be the best one to handle that. Michelle, I have a feeling that you're going to be the target of quite a few of these. So here's the first one. Are there, or do you anticipate there being lawsuits about business-to-business calls? Business calls are potential existing client cell phone, which doubles as a business line without consent and gets sued.
Yeah, absolutely. Unfortunately, business-to-business calls are lumped into the calls to cell phones. So I definitely anticipate that we'll see maybe standalone B2B lawsuits, but business phones that are lumped into just the lawsuits that involve calls to cell phones. So unfortunately, I know there were areas in the past where we didn't need to worry about calls to business phones. We do now with calls to cell phones.
Okay. The next question that we have, are more companies taking advantage of the existing business relationship or EBR excuse for making calls?
So the what we lost was, prior to October 16th, if you had an existing business relationship with someone, then you could use a pre-recorded message to call them on their landline. At least under the FCC regulations. The FTC, there were some separate issues there which we're not going to go into. So we lost that ability. So while I think that more companies are taking advantage of the EBR, not just for the legal sense, but by the way they're tailoring their marketing to learn more about their customers and to market to them in the way they want to be marketed to, I think companies are being much better about asking clients at the time, or asking customers at the time the relationship is formed, about how they want to be contacted. And a lot more companies are, a lot more sellers are out there getting that express written consent at the time that the relationship is formed, or throughout the course of the relationship. Because if you really want to have something that is going to protect you, yes, if you're not dialing on an ATDS, then that's going to give you a defensible position. But really the be-all, end-all is that you have your express written consent of your consumers, and that's certainly going to tell you how they want to be contacted. You know, there's a recent case that deals with a consumer that, and this was in the express consent, so this was a non-telemarketing call, in the express consent arena. The consumer had provided their cellular telephone number, but the company had unfortunately worded a request to call the consumer on their cell phone that the request was made in such a way that it was really a "don't call me unless I check this" box kind of thing. So you have to be very careful, even as you're finding out how your consumers want to be contacted, that you're getting that express written consent, that your forms are written in a way that aren't going to unintentionally run into problems like that. The court actually said that although they had provided their cellular telephone number, the way they had set up the consent made it clear that the consumer had not wanted to be contacted, so it counted as what they call a subsequent request not to be contacted.
Okay. There's a follow-up on that B2B lawsuit that we talked about in the previous question. So the person that's asking the question is asking, what's the likelihood of the lawsuit? In the suits discussed that have cropped up, are any of those B2B?
So, you know, I think it's likely, and what I would point to is most of the lawsuits that were brought by under the TCPA for faxes that were sent, those were business lawsuits. Businesses were receiving faxes. Most may be an overstatement, but a great many of those. So I don't think it is a far stretch to say that calls to business cellular phones are just as much at risk as calls to consumer cellular phones. I wouldn't distinguish between those types of things in your compliance tactics.
Okay, fair enough. The next question, Michelle, and this is, I believe, directed at you. For express consent, what language is palatable enough that people want to sign while still in compliance with the new regulations? Are companies finding people will give consent to get telemarketing calls from an ATDS? Do they get an e-signature on the consent form?
So I think, you know, I got this question because I just skimmed over what constitutes express written consent at the beginning of the Hangout. So, you know, when we're talking about express written consent, you have to have language that expresses the consumer's desire to be contacted on their cellular telephone. The way the definition is phrased in the regulation, it says that they have to be consent to receive a phone call on their cellular phone using an ATDS for telemarketing purposes. And you can't, and it requires a signature and the telephone number to be in that express written consent. So it's kind of onerous what you're required to do. To answer the e-sign question, can you get it through a recording or through an electronic means? The FCC stated specifically in their explanation of the new rule that e-sign was a valid way to get that express written consent. So e-sign allows for voice recordings and also for electronic recordings, as long as it witnesses the consumer's consent to whatever the transaction is here to be called on their cell phone. Now, as far as the specific language, we have never claimed to be a creative genius, but I have worked with a lot of very creative folks out there that know their customers, that know how they have to term things or term these requests in order to get express written consent. Comcast is a PACE member, and they've allowed us to use them as an example. They have, many of you have probably already heard this, but they kept track of all of the consumers that were purchasing services on the telephone who, and during the course of that purchase, they were asked if they would provide express written consent to be contacted on their cell phone for future transactions. And I'm sure I'm not wording it the way Comcast did, but that's in essence what they were asking for. And 70% of the time, the consumers would give express written consent. So yes, there are ways you can do it. Is there a magic formula? I haven't found a magic formula, but I can tell you there are some very creative folks out there that have worded it in a way that it's palatable to consumers. Sometimes I see it in terms of, yes, I want to receive future promotional offers or discounts on my cellular telephone through an ATDS, and they have a checkbox or some other type of means of validating. So work with your marketing folks. They're good at this type of stuff. Then get it blessed by your legal team.
Always goes back to that legal team. The next question is, I'm curious if we can call former customers' mobile phones to try and reacquire them on an ATDS.
This is the bad thing about, I just dribbled water. Hopefully no one saw that, but if you did, webinars are bad enough listening to yourself, but now looking at yourself, it's, I think that was a Hangout faux pas. Anyway, so you no longer have the EBR. So let's go back to what I think we cut out for a small portion of time. I received a text from Gary Brown, thank you, letting me know that we had cut out. But you still have to follow all the do not call laws. So before we even get to the issue of can we call them on their cell phone, we need to ask if we can call them at all first. So if you don't have an EBR with this customer, you're going to have to scrub against the do not call list prior to being able to call them at all in any way, on their cell phone, on their landline, on anything. So let's say that we don't have the EBR, but they're not on the do not call list. Then the analysis doesn't change from what we've been talking about with calling in a compliant manner for the TCPA. The EBR does not factor in at all to this analysis. I think the reason people talk about EBR around calls to cell phones is because we have this concept of express consent and that a consumer would have given their telephone number during the course of that relationship. But I don't want you to confuse that with these cellular phone regulations. EBRs have nothing to do with it. You just have to make that first analysis, though, of whether you can get around or cannot get around but comply with the do not call laws, either by scrubbing or having an EBR.
And the last one that I have is, and Jeff, this one might be for you, or Michelle, it might be for you. Are avatar technologies considered pre-recorded automated systems?
Wow, Jeff, I hope you know the answer to that.
I'm actually not familiar with that term. Is it avatar technologies?
Yep, it's capital AVATAR, avatar technologies.
So it was a great movie, and
yep, that's what I think too.
Now, Jeff, do you think they're just talking about these third world, and that's not the right term? Wow, Jeff, I'm going to be quiet. I hope you know the answer.
I don't actually, so I have no answer to that question.
I know that there are systems out there where there are made-up worlds where people go in and they use avatars. So
I hope that's not what the question was referring to.
A little clarity on that would be helpful. I would love to give an answer here.
We'll see if we get a follow-up. Okay. Well, that is all the questions that we did receive. So then what I will do is, oh, hold on, we just had another one come in. I'm sorry. Michelle, this one is for you. Do you think that Baird versus Saber decision is an interpretation that provision equals consent for informational auto-dialed calls, messages to mobiles?
Bear versus Saber. I'm not familiar with that, and I thought I knew all of the recent cases that were out there. I'm sorry, Chris. What were they saying was the holding in that case?
It's that, and its interpretation that provision equals consent for informational auto-dialed calls, messages to mobiles. BAIRD versus SABRE. Maybe I said it wrong.
Well, so there are a number of cases out there, and I'll tell you, I can give you the answer in general without knowing that specific case, because there's probably 7 or 8 that have been decided in the last couple of months that follow this lineage. But what I would want to start with is the Mays case out of the Southern District of Florida. It's currently on appeal in the 11th Circuit, and what the case says is that the FCC's interpretation of express written consent, that being that if a consumer provides their cellular telephone number, is express written consent under the statute. The Mays case said that that was not an appropriate reading of the statutory language of the TCPA. So that case was appealed, and it's on appeal. That is the only case currently out there that challenges the FCC's interpretation of express written consent. I could point to 5 other cases that have been decided in the last couple of months that reaffirm what the FCC has said is express written consent. That Mays case is only precedential in the Southern District of Florida right now, so you'll have to be careful if you're calling in that area, or understand that there might be a slightly increased level of risk there. But the case that they've mentioned is typical of all of the other cases that we're seeing out there. They're holding, the courts are holding that the FCC has given an appropriate interpretation of express consent.
Okay, I have, no, I'm here. I have a lot of people that have come to me with what avatars are, okay? So now we're all learning something, everybody, today, at least on this panel. Okay, avatars are snippets. It's a partial live agent, partial recorded call event used by many call centers, snippets of pre-recorded responses.
So that's an interesting area. So this is what I can tell you. The FTC has given an advisory and opinion to a company on this issue about using these pre-recorded snippets. So it's not just a pre-recorded message. It's got an agent that is involved 100% of the time with the call, and the agent has usually more than one phone call going at a time. And in response to what's going on with those 3 calls, it pushes a button or puts in a code, and a pre-recorded snippet, I guess that, I'm wondering if that's what they're considering an avatar, that pre-recorded snippet is what engages in the conversation. The companies that do this right, they do it well, and most of the time the consumers don't even know that it's a pre-recorded snippet that's being exchanged with them. So the FTC has said that that is not the type of pre-recorded message that the TSR, that the FTC's regulation, had intended to prohibit. The FCC has not given a specific opinion on that issue, and there are not any cases that I'm aware of as I sit here right now that have said that that would be the type of pre-recorded message that requires express written consent under the new TCPA, but I will tell you I have not researched that issue under the new law. And that is something that I would definitely get a legal opinion about before you start using that type of technology under the new TCPA requirements. But right now I don't know of anything that would prohibit that just in and of itself as a pre-recorded message that would require express written consent.
Interesting, very interesting. And thank you for the education on an avatar. All right, everybody, I think that covers all the questions that we have. I want to thank everybody for joining our Google Hangout today. I want to let everybody know that this video will be available on YouTube after the Google Hangout is complete. It's also going to be available on the PACE website, which is paceassociation.com. I also want to remind everybody that the 2014 annual PACE Convention and Expo is coming up April 2nd through the 5th. In Hollywood, Florida at the Westin Diplomat. You can find out all the information on our website at paceassociation.com. If you do have any other questions related to this Google Hangout that we didn't get to answer today, please do email them at tcpa@connectfirst.com. You can also email me at Chris, CHRIS, .Herrick, which is HAERICH at paceassociation.com, and we can pass them along to the appropriate people as well. Thank you, everybody, for joining our Google Hangout today. We greatly appreciate it. Jeff, Courtney, and Michelle, thank you for your time today. You were all fantastic. I wish everybody a great rest of your day and a great rest of your week. Take care. Bye now.
Thanks, Chris.
Thanks. Bye.
Bye, Chris. Thanks.